Right. So we had, we were talking about chapter 2 of title 3. What is title 3? What was title 1? So titles are basically, each title is subdivided into chapters. So the first one was just introduction kind of thing. The second one was prohibited AI, and title 3 is high risk AI. Okay. In that high risk, chapter 2 is requirements for high risk AI systems. So this was our, so this is where you have title 3 high risk AI systems. Chapter 1 was the classification. Okay. So they told us what are the high risk AI systems, and now in chapter 2 we are talking about the requirements of a high risk AI system. That means once you have classified, once you know that a particular application is classified as high risk AI, what should be done with that? So what is the first thing? We had talked about this. What is the first thing? So you have to be in compliance with the requirements set out in this chapter. That is the first thing. Okay. And so this was just one thing, mandatory for all high risk AI systems, this compliance. This second paragraph just said that those things, those products or components which fall under the Annexure 2 section A, that means regulations that are already there. So there are already some regulations governing them. Then don't put an overburden on them because of this regulation. Whatever good you are doing there will be more or less accepted here as well, and you are supposed to do just the difference if required. So who is going to manage the risk? Who do you think is supposed to manage the risk? See, usually governments don't make regulations for themselves. They want to regulate something else. I mean, of course, government will be included in some cases, but so in this case they must be talking about the providers, mainly providers. Okay, and then I mean, just because a circumvention of the laws will not be allowed, so every other thing will be in. For example, the authorized, what was the phrase? Authorized? What was that phrase? Authorized representatives, right. Okay. So the risk management system shall be understood as a continuous iterative process planned and run throughout the entire life cycle of a high risk AI system, requiring regular systematic review and updating. It shall comprise of the following steps. So all you are supposed to do is continuous iterative process as long as the AI is on the market, systematic review and updating. Now, so you have to identify and analyze the known and foreseeable risk. You have to estimate and evaluate the risk that may emerge. That means they are not known and they are not reasonably foreseeable, but that may emerge. Okay. And so this one talks just about in accordance with the intended purpose. This clause also states that under the conditions of reasonably foreseeable misuse. This is reasonably foreseeable risk when you use in the way it was supposed to be used. This is a reasonably foreseeable use, but that use was not intended. So that is the misuse. Now these two clauses are looking into the future. So you have to identify, analyze, known, reasonably foreseeable, may emerge, reasonably foreseeable misuse. So we are talking about what may be the way in which these things may be used or may be misused. So these are looking mostly into future. C clause, C part says evaluation of other possibly arising risks based on analysis of data gathered. Okay. So they lay out the whole thing in Article 61, we don't care. All we care about is, now this you do retrospectively. So some data has gathered, right? Now you start analyzing this. So this is not looking into the future, but looking into the past, how your AI has behaved. And finally, this says that, so not much details related to B and C in this article itself, but we concentrate more on part A for subsequent paras. And part A was about the known and reasonably foreseeable risk, right? So the remaining paras, unless they explicitly mention, they don't talk about what? For example, risks that may emerge or reasonably foreseeable misuse. You see, this paragraph clearly states adoption of appropriate and targeted risk management measures designed to address the risks identified pursuant to point A of this paragraph in accordance with the provisions of the following paragraphs. Okay? So you have to adopt the appropriate risk management system measures pursuant to point A, and point A is just talking about known and reasonably foreseeable risk. Done? So we proceed. Anybody finds this like we had done this before? किसी को ऐसा लग रहा है कि अपन पहले कर चुके हैं? क्योंकि अगर ऐसा नहीं लग रहा है then it's okay for me to repeat this. And I'm pretty sure नहीं लग रहा होगा. Anyway, so let's continue. The risks referred to in this paragraph, which paragraph? Shall concern, which paragraph? Shall concern only those which may be reasonably mitigated or eliminated through the development or design of high risk AI system or the provision of adequate technical information. What might this mean? I mean, see, as a computer scientist, see, we understand the English meaning of this. Okay? If you read it 2-3 times, you will understand what does it mean in English. The problem with this act that I understand and the way people are talking about it, if you ask it from a developer's perspective, this is too vague. So, shall concern only those which may be reasonably mitigated or eliminated through development of design. So, what are the risks that can be mitigated through the development or design of a system itself, right? Or the provision of adequate technical information. So while we understand in English, but how do you achieve this while developing a system? That is super unclear to me. Not just unclear, because how do you decide? Because see, if this were just guidelines, fine, but this is law. So companies may be penalized for this. So not just guidelines, this is law. And when in law you say things like which may be reasonably mitigated or eliminated through the development or design of the high risk, that means high risk AI system should be developed and designed in a way such that the risk may be reasonably mitigated or eliminated. This leaves too broad a room for discussions on both ways. Some people can come and say, see, we had done our reasonable development, right? We had done our development and design in a way that reasonably mitigates the risk of AI system. But I mean, how to make it concrete? I have a problem there. Do you see what I'm trying to say here? Yes. So I expect you guys to think from a computer science perspective and hence question almost every line that is written here. So the risk management, now this is, the risk management measures referred to in paragraph 2, point D, shall give due consideration to the effects and possible interaction resulting from the combined application of the requirements set out in chapter 2. What does it even mean? With a view to minimizing risk more effectively while achieving an appropriate balance in implementing the measures to fulfill those requirements. What is it? So, as a developer, this is giving you some breathing space or taking that away from you? See, what are the above things saying? So, for example, this says you have to develop and design a system in a manner that mitigates the risks. Okay. Now, what is this paragraph saying? So, this was far more vague. This kind of covers everything. Now, this in a way tries to give you some breathing space, which says the risk management refers in paragraph 2, point D, which is this one, for which this paragraph also applies, shall give due consideration to the effects and possible interaction resulting from the combined application of requirements set out in this chapter. So, after reading this maybe 4 or 5 times, you will understand what it means in English, at least that is my limited. Okay. You will understand what it means in English, but what it means as a developer, I don't get it. What I just get from this is, basically it means that there should be a balance in risk management and the ease of doing business. I mean, don't make this, making this risk management system so difficult that AI companies are not even able to operate. Okay. To me, this is what it means, but how do you make it concrete? No idea. The risk management measures referred to in paragraph 2, point D shall be such that the relevant residual risk, what does it mean? So, you tried to mitigate risk, you tried to eliminate risk, but now let us say you still come and say ki, see, somewhat risk is still left. Okay? So, now this relevant residual risk associated with each hazard as well as the overall residual risk of the high risk AI systems is judged to be acceptable. So, whatever risk remains, if that is acceptable, right? So, the risk management measure should be such that whatever remains risk, whatever risk remains, that should be judged to be acceptable. Huh? In identifying the most appropriate risk management measures, the following shall be ensured. So, as far as possible, remove risk by design or by development. Okay? That is what we are saying, as far as technically feasible. Now, this is so debatable, as far as technically feasible. So, this will vary from even company to company, right? OpenAI might be, so technical feasibility for OpenAI may mean something, for Microsoft may mean something else, for some other low tier companies may mean something else, right? So, this is going to create a huge mess on a case by case basis. Where appropriate, implementation of adequate mitigation and control. So, if risk cannot be eliminated, mitigate it adequately. So, you have to ensure the following, that mitigate through design and development, where appropriate, implementation of adequate mitigation and control measures addressing the risk that cannot be eliminated. Provision of the required pursuant to article 13, we will see article 13, referred to in this where appropriate training to deployers. This is a good point. What does it say? You as a provider, you give your AI to someone else, right? You shouldn't be able to say, Kisi, I have given it to you, now it is your responsibility. No. You are supposed to explain, or you are supposed to train the deployers as well. So don't assume that users are tech savvy, your deployers. So high risk AI systems shall be tested for the purpose of identifying the most appropriate and targeted risk management measures. What does this testing mean? I don't find the definition, right? So there is a definition for test data set, but what does this testing mean? Or maybe I missed it, right? But right now I don't really understand what does it mean. High risk AI system shall be tested for the purpose of identifying the most appropriate and targeted risk management measures. Testing shall ensure that high risk AI systems perform consistently for their intended purpose and they are in compliance with the requirements set out in this chapter. This is too easy to write for legislatures than to implement for developers, because we know that every team has a developers and then testing team is also there. So these are the things that are already happening, right? But now they are mandated by law. So this brings a huge difference. All these things are already happening, but now it is mandated by law. So for example, if testing team does some mistake, does some oversight, so a software engineer there might be legally liable. So the idea is you can't be careless if your company is implementing a high risk AI. Now they talk about it. So testing procedures may include test in real world conditions. This they define in accordance with Article 54A. We don't go there. Testing of high risk AI system shall be performed at any point throughout the development process, but prior to the placing on the market. So this is important. You have to appreciate the fact that now this is mandated by law. So if you are part of a testing team, right, later we will see you have to document everything. So throughout the development process and in any event prior to the placing on the market. So before you place it on the market, put it into the service or in use, you have to do what? Testing. Okay. Now testing shall be made against prior defined metrics and probabilistic thresholds that are appropriate to the intended purpose of the high risk AI system. When implementing the risk management system described in 1 to 6, providers shall give consideration to whether, in view of its intended purpose, the high risk AI system is likely to adversely impact persons under. So while you have done everything is good, but if your AI, high risk AI is doing something adversely to children or to, let's say, elderly or to some other vulnerable group of people, you have to take care of that also, that this is also not happening. So for example, high risk AI may be okay for adults but not for children or any other vulnerable group of people. For providers of high risk AI systems that are subject to requirements regarding internal risk management processes under relevant sectorial, so okay, we don't go into this. Now Article 10. Article 10 at a very high level states you have to ensure the quality of data and the training process, keeping in mind the bias and where they have the impact. This is, I think, the high level understanding of at least mine. So high risk AI systems which make use of techniques involving the training of models. Yes. we are talking about training specifically here, right? Techniques involving the training of models. You could have AI systems where training is not required. Okay? Earlier methods, like those devised before machine learning, right? They did not really require. So those logic based methods, they don't really require training in the today's way the we understand it. Okay? So data shall be developed on the basis of training, validation and testing data sets. You should have 3. Law says you should have 3 data sets. You just can't say training and testing only. It says shall be. Shall means mandatory. On the basis of training, validation and testing data, they are defined, but I won't go there because we understand them. Okay? So now law mandates you should have 3 sets that meet the quality criteria referred in paragraph 2 to 5. So what is this whole thing saying? This first paragraph? So if you are using training, if you are building your AI through training, you should have all these 3 kinds of data sets, and they have to meet the quality criteria. Where do we infer those quality criteria from? They are told us in paragraph 2 to 5. Okay? So we talk about the quality criteria now. There is no undo here. So training, validation and testing data sets shall be subject to appropriate data governance and management practices appropriate for the intended purpose of the AI system. Those practices shall concern in particular relevant design choices. Okay? Whatever the design choices for the system, data collection process and origin of data, and in case of personal data, the original purpose of data collection. कितने लोग सुन रहे होते हो? So the relevant design choices, the data collection process and origin of data, and in case of personal data, the original purpose of data collection. So let's say if your company is processing personal data and it has purchased a personal data set from someone else. And let's say it was purchased for some other reason. Can you start using and do AI on it for some other reason? You can't. You can't process. So personal data has another layer of safeguards. Okay. So for example, I can buy data, I can buy AI data, right, some other data that is not personal, and do AI on this. But I cannot purchase a personal data from somewhere. Firstly, this itself will not be allowed. I mean, this itself will have a lot of restrictions through GDPR. But let's say if this purchase is allowed, even then you can't process that to do some kind of AI. Unless so you have to take care of all these things. Relevant data preparation, processing operations such as annotation, labeling, cleaning, updating, enrichment and aggregation. This document now less looks like a legal document, this is more like a computer science document now. So you have to do all these things: annotation, labeling, cleaning, updating, enrichment and aggregation. The formulation of assumptions, whatever assumptions you are making, notably with respect to the information that the data are supposed to measure and represent. An assessment of the availability, quality, quantity and availability, quantity, suitability of the data sets that are needed. So, if you are developing it for task 1 and if your data is not suitable to do that task, right, then basically it does not go through the quality check in this particular part. Okay. So, a data, what are we talking about from paragraphs 2 to 5? देखें कितना सुनते हो. What was paragraph 1? Paragraph 1 said if you are doing AI through training of data, you should have 3 data sets and all your data sets and all these data sets should meet the quality criteria. Where is the quality criteria mentioned? 2 to 5. So, all these are quality criteria. Examination in view of possible biases. Okay. So, basically no bias data, you have to examine the data that there are no inherent biases in the data itself. Appropriate measures to detect, prevent and mitigate possible biases. Identification of relevant data gaps. So, remember you might have data sets in which some values are missing, or you might have data sets in which, let us say you forgot to collect one particular feature. Now, training, validation and testing data sets shall be relevant, sufficiently representative and to the best extent possible free of errors and complete in view of the intended purpose. They shall have appropriate statistical properties including where applicable. So, if this is how I start teaching you machine learning, right, see how broad this is. So, training, validation and testing data sets shall be relevant, I am done, relevant, you decide, sufficiently representative and to the best extent possible free of errors and complete in view of the intended purpose. They shall have the appropriate statistical properties and I am done. Okay. Appropriate statistical properties including where applicable as regards the person or group of persons in relation to whom the high risk AI system is intended to be used. These characteristics of the data sets may be met at the level of individual data sets or a combination thereof. Data sets shall take into account to the extent required by the intended purpose the characteristics or elements that are particular to the specific geographical contextual behavior. What may this mean? Remember, we are still talking about what? We are still talking about the quality criteria of the data sets. So, where does this fit in? You collected, for example, you collected some kind of data sets, let us say facial recognition data set, whatever was legally allowed in USA, and you try to do something in India using those faces, that may not make sense. Okay? So, you have to take into account the specific geographical, contextual, behavioral or functional setting within the high risk AI systems, and of course, everything should fit within the intended. So, right, it of course cannot lie outside the intent of use. This whole thing just says this thing that the personal data has to be handled much more carefully. I forgot to write much here, right? Much more carefully. And basically this refers to various articles of GDPR. So paragraph 1 talked about if you are doing machine learning through, if you are doing AI through training, validation and test sets, then the quality criteria must be met. Quality criteria is provided in 2 to 5, 2 to 4 is over. 5 says if you want to geographical is done in 4. So if you want to process personal data, I give you more criteria here. So first question is, why do you need to process the personal data in the first place? Okay. So it says the bias detection and correction cannot be. So the following conditions shall apply in order for such processing to occur. So if you want to process personal data, then these things will apply. The bias detection and correction cannot be effectively fulfilled by processing other data. So what does this line say? This says that you just require personal data, there is no other way of removing bias. So cannot be fulfilled by processing other data, including synthetic or anonymized data. So only in that case you can go and process the personal data, if at all. The special categories of personal data processed for the purpose of this paragraph are subject to technical limitations on the reuse of personal data and state-of-the-art security and privacy preserving measures. I don't understand this state-of-the-art security and privacy preserving measures, including pseudonymization. So anonymization, you can't anonymize everything completely. Pseudonymization means there is some probability that you can trace back who was the person. So anonymization, I would understand that as a complete anonymization. There is no way to do reverse engineering and reach the person. But in this case, there might be some hard way of doing some kind of reverse engineering and still be able to figure out who is the person we are talking about, right? Special categories of personal data processed for the purpose of this paragraph are subject to measures to ensure that the personal data processed are secured, protected, subject to suitable safeguards, including strict controls and documentations of the access to avoid misuse, to ensure only authorized persons have access to those personal data with appropriate confidentiality obligations. 4-5 सिक्योरिटी के कोर्स खत्म हो गए हैं इसमें, ठीक है? Okay, so the point here is, while this makes sense, but it doesn't make much sense to developers. Of course it makes sense, but how to achieve all this? So, the breathing space that developers might be looking for, I don't know if that is there. The special categories of personal data processed for the purpose of this paragraph are not to be transmitted, transferred or otherwise accessed by other parties. If you are working on something, you say we want to give some other party for processing it. No. Cannot be transmitted, transferred or otherwise accessed by other parties. Not even accessed. So you can't even tell them, see, come here and do it. So if that person does not belong to your company, then not even accessed by those persons, right? Now see, after going through this, and let's say if at some point of time I will take GDPR, after going through these two laws, you will think, sitting 9 to 5 in your office, whether every minute, whatever you did, whether it was legal or not, right? To this extent, these laws are covering everything. So let's say, for example, you are doing something, you call your colleague and see, please have a look at this problem. You don't know whether this person was authorized to have this access or not. And then if somebody suffers some harm, these were legal obligations, right? So the special categories of personal data, this is fine. Okay, the special categories of personal data processed for the purpose of this paragraph are deleted. More, you have to delete once the bias has been corrected or the personal data has reached the end of its retention period, whatever comes first. Okay, so either bias is removed, delete it, or the data was given to you for 3 months and 3 months are over, delete it. It does not matter whether you are just 2 steps away from finishing the task. The records of processing activities pursuant to regulation, see 2016-679 is GDPR. Okay, and this is again, so GDPR and then how police should process personal data and all these things, most of them are there. And then you have to justification why the processing of special categories of personal data was strictly necessary to detect and correct biases and objective could not be achieved by processing other data. Now this gives you the third level of scrutiny. First was quality management. Then in quality management we saw if you are trying to process personal data, other rules. This says if you are processing the special categories of personal data, then third level. So GDPR basically defines all these things, we are not doing that, but so for the development of high risk AI systems not using techniques involving the training of models, paragraph 2 to 5 shall apply only to the testing data sets. Okay. By the way, this in practice is not happening in today's world. So most likely this will remain a dead letter, will not be invoked as such, but you don't know AI, right? We don't really know, and we don't know how fast this technology is evolving. I mean, we know how fast the technology is evolving, but we don't know what might happen in the future. All right, Article 11, technical documentation. Now, okay, it seems I have not saved the latest version, because in the latest version I have written here or somewhere, I don't know. So maybe somewhere there. But this technical documentation is essentially a very big research paper that you are supposed to write if you are working in an AI company that is providing solutions to EU. So the technical documentation of a high risk AI system shall be drawn up before that system is placed on the market or put into service and shall be kept up to date. Okay. So you might be having positions just to do this. That's what I suspect, because it's not easy. So if you have a team of 10, you might have to hire 11th who will take care of just this requirement. So the compliance cost of this act, as some people are trying to assess, is roughly 300k euros. Okay. Now assuming this is super overestimate, let's say make it 1/10, still 30k euros. So you have to hire at least one person who takes care of just this act. He or she is not going to develop anything for you, nothing, just the compliance with this act. And you guys can become one of those. All right, last article. So the purpose of this is to mandate having a documentation that shows compliance. Okay, you just can't say, see, we had made what was that? What was Article 9? Risk management system. You can't simply come and say, no, see, we had made a risk management system, but if you had done so, show me the documentation, right? So this documentation is going to ask everything that you have done, including what we'll see later. And you will be surprised to see including what. So for example, let me quickly go there. So Article 12 says you have to do record keeping. Now how is record keeping different from a documentation? Here they say you have to make automatic logs over the duration of lifetime of the system. So just coding your AI system is not sufficient. You have to do extra coding that logs, that automatically logs things that are listed here. Okay? So the technical documentation shall be drawn up in such a way to demonstrate that the high risk AI system complies with the requirements set out in this chapter. If you understand this line, you understand the meaning of Article 11. Technical documentation is, the technical documentation shall be drawn up in such a way to demonstrate that the high risk AI system complies with the requirements set out in this chapter. Whatever requirements we have seen before, there was a risk management system, there was a quality control of data and data governance, how to deal with the personal data. So you have to document everything, how have you dealt with them. And provide national and competent authorities and notified bodies with necessary information in a clear and comprehensive form to assess the compliance of the AI system with those requirements. Right? It shall contain at a minimum the elements set out in Annexure 4, we will see that. SMEs including startups may provide the elements of technical documentation specified in Annexure 4 in a simplified manner. These are procedural things, I will skip it. Where high risk AI system related to a product. Okay, so now again, where Annexure 2 Section A applies, what might this mean? You guys should tell me now. Whenever you see Annexure 2 Section A applies, what does it mean? I have underlined the relevant points here. This should give you sufficient information even if you are listening 20% of what I am saying. Okay, I won't judge. See, Annexure 2 Section A refers to all those other regulations of European Union, right? So if you are showing compliance there and if you are documenting something over there, right, then we don't want to overburden you with this extra thing. Do only what is strictly required in just this case because you are already showing a lot of compliance. Okay? And then Commission is empowered to delegate. So Commission can amend Article 4 that we'll see to keep up with the pace of the technology. So now we quickly go to okay. Technical document. So yes, I had written it here. So it is almost a research paper on the high risk AI in consideration. Basically document each and every detail to boost confidence in the application, right? And this you are doing for whom? This, so you are part of a company that is providing AI solutions in EU and you don't want your company to pay fine, right? And fine is super high. It is of the order of 6 to I think 7% of your gross annual turnover, not profit, turnover. Okay. So quickly do this. So the technical documentation referred to in Article 11 shall contain at least the following information: a general description of AI system, including its intended purpose. So think of this box, right? Think of AI is coming in this, and you are supposed to tell me what is the intended use, intended purpose, how the AI system interacts with hardware or software, including other AI systems that are not part of this AI system itself, the version of the relevant software, the description of all forms in which the AI system is placed on the market. A software package embedded into a hardware, downloadable, API, everything. Description of hardware on which AI is intended to run. So basically you are supposed to give me the catalog that comes, right? Where the AI system is a component of products, photographs or illustrations showing external features, marking and internal layouts of those products, basic description of user interface, instructions of use for the deployer, a basic description of the user interface provided to the deployer wherever applicable. So what was A to G? A to G was just the general description. Now they are talking about the detailed description. And detailed description of what? You see it here now, everything. Methods and steps performed for the development of AI system, including where relevant recourse to pre-trained systems. So if whatever AI you are using, if you are using some other system, that's, for example, if you are using BERT, so BERT is already pre-trained. So recourse to pre-trained, you have to tell that you are using BERT, or tools provided by third parties and those and how these have been used, integrated and modified by you. The design specifications of the system, namely the general logic. Okay, so you have to tell them why did you program it this way, of the AI system and of the algorithms. The key design choices, including rationale and assumptions made, also with regard to person or group of persons or which the system is intended to be used. Okay. Which one? But you are supposed to give details. So that's why compliance cost. And I think it is 300K, it is not 30K. The key design choices, okay, so fine. The description of system architecture, so your neural network, how it interacts with other things, LSTMs or BERT or whatever, okay. No, but whom you are supposed to give? So. This is the detailed description, and you are supposed to do this documentation for authorities. When authorities ask you for compliance, you are supposed to show it to them, not everyone. It won't go with my AI as such, not everything. Not everything will go, it will only go to the notified authorities. No, so authorities, we won't see that, I mean we won't do it in, but notified authorities are of course supposed to keep it confidential, right? Where relevant, so the computational resources used to develop, train, test, validate AI system, GPU and everything. Labeling procedures, example, supervised learning, data cleaning methods, outlier detection. So basically, if I want to wind up the class now, you have to keep a record of everything and document everything, not just keep a record of it. तीन बजे क्लास थोड़ी है भी नहीं है. So बस थोड़ी सी देर है ना. Let me finish this. कितना सा है? Almost done. नहीं, almost done. I won't take too much of time here. Validation and testing procedures used. Okay, so how you trained, which hardware you trained on, and then finally validation and testing procedures used. So basically wherever you can fool others in your AI, right? This act ensures you can't do that, at least not for high risk AI systems. This is what it means. Okay. Now, yes.
ऐसे तो मैंने सब कुछ ही उस अथॉरिटी को सब कुछ दे दिया, लाइक मैं किस जीपीयू पे ट्रेन कर रहा हूँ, मैं किस उस पे ट्रेन कर रहा हूँ.
See this one line too, GA. It says cyber security measures put in place. 5 words for them, and I don't know what does it even mean. So you have to document this. I give you 3 days. How will you document this? Nothing. That's why I am saying कि this is a whole big research paper. Detailed information about the monitoring, functioning, control of AI systems with regard to what? Its capabilities and limitations in performance, including the degrees of accuracy for specific persons or group of persons on which the system is intended to be used, and the overall expected level of accuracy in relation to its intended purpose. Foreseeable unintended outcomes. Human oversight measures, Article 14 will go. Description of appropriateness of the performance metrics for specific AI systems. Detailed description of risk management system. And one more thing, description of relevant changes made by the provider to the system through its life cycle. Attendance कर दो जब तक. Done? The list of harmonized standard. आप लोगों की क्लास हो नहीं हो, मेरी है भाई 3 बजे. So done, right? This is something that is not that relevant anyway. Yes.
सर मैंने तो जैसे सपोज आपको अथॉरिटी वाली मेरा वो है एआई सिस्टम है, मैंने सब कुछ बता दिया, मतलब कुछ छोड़ा ही नहीं, सब कुछ ही बता दिया, एंड देन मैंने अगर पेटेंट नहीं कराया था एंड मेरा आइडिया कैसे लीक हो जाता है.
See, first of all, I know a little bit of patent law as well. So ideas are not patentable. Not in India.
नहीं, बट अगर रनिंग है, सपोज मार्केट पे लॉन्च कर रहा है, देन उसके बाद मैं उस बॉक्स के साथ सब कुछ इंफॉर्मेशन अथॉरिटी को दे रहा हूँ एंड वो लीक हो जाती है, तो देन तो अथॉरिटी भी क्वेश्चनेबल.
But if you have got something patented, no, let's say you have patented something. If you have already patented something, then there already exists an authority that has all the information, the patent controller. See, in this world you have to trust the government, full stop.
ऐसे तो सर खुद का प्राइवेट आइलैंड खरीदो, फिर उस पे एआई की मॉडल ट्रेन करो.
See, the idea, no, the idea is, if you want to place it on market, put into service. If you are doing something, you go ahead and do whatever. Exactly. So you can't do wrong to my population and still make money from it.